are we? Ah, interesting. So I am seeing, Genevieve, are you still there? I seem to have gotten kicked out.
I am still here.
That is so weird. I do not see your screen any longer. Ah, there we go. Great. I'm hoping that's it. So does the screen say possible contingency language on it? Yes.
It
Okay, great.
says, this is that one? Okay.
Good, good. There we are. All right, so here's one of the first questions. Is a question, Dan. My buyer wants to know if they had the right to install an electrical vehicle charging station after they purchased a condominium. What do I tell them? Well, the first thing we want to do is ask where you are in this process, right? And so if you're representing a buyer who's considering making an offer on the property, the answer is yes. As a matter of fact, there is a civil code that allows for this. And there's your citation there, Civil Code Section 4745. But more practically speaking, right, it may be a question of what does the HOA already have? How cooperative is this HOA? Just because the law says that they have the right to do this doesn't mean that this HOA is going to be particularly cooperative, right? And then, of course, there's a question about cost and who's going to pay for it, right? So you can tell your client, and I give you sort of a sample answer here. I appreciate your direct questions regarding the potential right to install an EV charging station. As we have discussed, there's a California-specific law, and here's a citation to it. Part of these laws, the seller is supposed to disclose if an electric vehicle charging station is installed in a common area or an exclusive use common area. Each seller whose parking space is on or near that charging station must disclose its existence, and that the buyer will have the responsibility set forth in the statute. And then it says, I'm quoting the highlighted section of the EV stations. I'll make a request to the seller's agent to confirm any specific knowledge. It's possible the seller has no personal knowledge. I encourage you to research these rights before writing the offer, and certainly before removing any contract contingencies. Many articles are available, and here is one. So that's sort of a response that you could have to your client. Practically speaking, right, now the question is cost, right? And I don't know all the answers on cost. So yes, you have the right as an owner to have access to or have installed an electric vehicle charging station. That's what the civil code is all about. But I think it puts the cost potentially on the individual who's interested. And so trying to figure out those costs, if the HOA is or isn't cooperative, is going to be part of this process. Okay. Any questions on that one? Now, might you want a special contingency language? Yeah, your client might. If you have a regular investigation contingency, this certainly can be part of that. But let's say your client is otherwise satisfied with the condition of the property. They wish to remove that investigation contingency, but they want a special contingency related to this. Well, let's look at the next slide, and we'll look at some potential language there. And so here we go. You could say something like, as a contingency of this contract, buyer shall have so many days to investigate the HOA policy regarding EV charging stations. If dissatisfied and buyer's sole discretion, buyer may cancel the contract. Or as a contingency of the contract, buyer shall have so many days to petition and obtain from the HOA a waiver of the current EV charging policy as stated in the CC&Rs, because maybe the CC&Rs are outdated, haven't been updated, don't reflect the current law, and the buyer or prospective buyer wants to make sure that the HOA is willing to put in writing that they're amending those rules. And so that's another idea. Or the third one, as a contingency of this agreement, buyer has so many days to consult with an attorney to confirm in buyer's sole discretion the rights to install an EV charging station. If dissatisfied, buyer may cancel the contract. So those would be three good alternatives for you. Any particular questions on this before we go on to the next one? And Barbara Friedman, let me know if you can't hear me well, and I'll speak up. Okay, let's go on to the next one. Okay, so this reminds me, one of those options, right, in investigating the property was to speak directly with a qualified California real estate attorney, right? And that third option was I want to confirm my rights regarding EV stations with a California attorney. Often, you and your client are having a discussion, you're making a recommendation to the client to go ahead and talk to an attorney. And sometimes we're not sure whether they really did or not. And so I would love to see you, as a matter of course, sort of hold your client's feet to the fire, make sure that your client is the one who is making the decisions. The worst kind of client in the world to have is one who says to you, Dan, I don't know. I think I'll rely on you. You tell me what's best. That is absolutely the worst client. What they have just said to you is, I don't want to make the decisions, and I want you to make it all magically work out for me. And later, if I'm not happy, I'm going to sue you. That's really what they just said. So it's very important that all of your correspondence is somewhat agnostic. And what I mean by that is you're simply laying out the options for your client. You're putting out some pros and cons. You're trying to identify risk. You're explaining to them that this is entirely their decision, and then you're forcing them to make it by saying, okay, here are your options A and B. A has this going for it, and B has that going for it. Ultimately, of course, the decision is yours. How would you like to proceed? Please let me know. Okay? And if the reply is, well, what do you suggest? And frankly, your reply to that is, I suggest that you choose the alternative that works best for you. Let me know, and I'll convey that to the other party. Okay. And so this particular slide here in front of you right now, this confirming attorney advice, is sort of along those lines, right? So the question from the agent was, Dan, I followed your advice and I sent my client to speak with a qualified California attorney. The clients have now come back to me with instructions on how to proceed, but I don't have anything from the lawyer. I'm still a little concerned. What can I do to protect myself? So sometimes, frankly, you're concerned that they're lying to you and they didn't really go talk to a lawyer. And so I would love to see you have a back and forth confirming email that says, dear client, I wish to confirm you've met with a real estate attorney to discuss the CC&R provisions regarding the EV charging station and your rights moving forward, including the civil code that we discussed. The attorney has advised you that you do not need a special contingency added to the offer. You have instructed me to draft the offer without any special terms related to the EV charging station. I remind you again, just because the law is on your side does not mean the HOA necessarily understands the law. There may be time and effort and expense in pressing your rights. Did you discuss with the attorney, as I suggested, a contingency for the HOA to affirm your rights? ? Please confirm how you want me to proceed. I know that's a lot, but sometimes, frankly, you don't trust your client. You're not sure that your client has really told you the truth, particularly when you've sent them to see the advice of an attorney. And so I want you to confirm it in writing to the best you can. Any questions on this? Okay. Let's see what the next one is. Oh yeah, I like this one. So you have a listing in an HOA. And so what's going to happen? Well, ahead of time, hopefully you have a good disclosure packet ready. You've looked at all the CC&Rs. You made sure that everything's updated to the best that you can. Perhaps you've read the meeting minutes. Perhaps you haven't, right? But they're in your disclosure packet. But ultimately and invariably, the buyer's going to ask you some questions, right? And what are they going to ask you? They're going to ask you about pets. They might ask you about smoking, might ask you about barbecues. They might ask you about those electric vehicle charging stations. If they're particularly savvy, they might be asking you about floor coverings. And do they really enforce that 80% rug rule or whatever it might be? They're probably going to ask you about noise transmission, right? And so this puts you in a difficult position, right? Prospective buyers are constantly asking what the HOA allows and prohibits, right? And if you're a good agent, you're worried about getting it wrong. And so the question here is, what do I say, right? So that's what we're looking to here. And so what your response is going to be, let's say to the buyer's agent, is, here's an example. Dear agent, you ask a great question regarding whatever, dogs, whatever it might be. I point you to the CC&Rs and to the various publications drafted by specialist HOA attorneys on what HOAs can and cannot do. CAR has several great articles and Q&As available to realtors for their own edification and for their clients, right? And then you could send them to this CAR.org risk management site that has those Q&As. One of them is a Q&A right here, condominium and other common interest development disclosures, right? And there's a link to it. So what you're saying is, listen, all your answers are in the CC&Rs, right? I want to help you, but I don't want to get it wrong, right? And so this is sort of like dating. You don't want to raise a red flag. You want to be easy breezy, right? But you also don't want to go out on a limb and say, oh, yes, it does allow this, or yes, the HOA has in the past allowed this. Just because the HOA has in the past allowed something according to your client, right, which you may or may not really be able to verify, doesn't mean that the CC&Rs allow for that, right? And ultimately, any waiver in the CC&R rights and rules in the past might not happen in the future, right? The new board or the new neighbor who moves in upstairs may seek to enforce the rules as they're stated in the CC&Rs. So your client needs to be willing to live with those rules, okay? And so your email can go on to say, I encourage your clients to research this issue before drafting their offer and certainly before removing contingencies. And I think this is an important point. If the buyer is worried about dogs, for instance, right? I have a dog. I'm not moving anywhere that doesn't allow me to have my dog, right? My dog is now an emotional support animal, so it wouldn't be an issue. I could bring that dog to the HOA, even if the CC&R said otherwise, because California law is on my side. But if your client is concerned about the dog, for instance, isn't it best to try to figure this out ahead of time? Or if you know as a listing agent that the buyer is concerned about their dog, well, let's not get in contract and let the contract blow up over the dog issue, right? Encourage them to research and understand what the rules and regulations and their rights are before they make the offer, and certainly before they remove contingencies. I think it's in everybody's best interest, okay? And then finally, if your clients, the sellers, have something they wish to say on this particular subject matter, right? You need to encourage them to make sure it's certainly accurate. But if your sellers are willing to convey something, then here would be an example of what you're saying. You say, as it says down here, I spoke to the sellers and they have given me permission to convey the following. A, they don't have an EV. B, they do not recall any specific discussions regarding charging stations, but they do not regularly engage with the HOA and have not attended meetings and do not regularly read the minutes. And C, the property is professionally managed by the ABC Management Company, telephone number such and such. We encourage you to call them. Okay. All right, any questions on that? Okay, let's go on to the next one. You know, this is sort of the flip side of the same coin, right? You have a listing, and instead of having an HOA, there are tenants, right? So you're representing the seller's renting the property. There are tenants. Does the buyer ask questions about the tenants? Oh my God, yes, they do, right? And how do you describe the tenants? What can you say, right? And so there's a lot of issues here. One of the issues is getting it wrong, right? So anything that you say is going to be relied upon by the other side. And so this is like getting a disclosure wrong. This is also a reminder that most of your information comes from third parties. And so whenever you're describing some detail about the property or its condition, you always want to be ascribing that particular disclosure to its proper source, right? And so who was the source, right? So the answer there is, my sellers conveyed to me the following, right? Or I spoke directly with the property manager regarding the tenants who told me the following, right? And that always gets followed up with the old, I have not and will not verify information provided by third parties. And a lot of you have that at the bottom of all of your emails because it's so important, right? All of your emails actually say at the bottom, I have not and will not verify information provided by third parties, buyer to investigate. So this is something similar here. So here's the question. I'm listing a tenant occupied property. The agent for the buyer has submitted a list of questions. What can I say? And so here's an example of acceptable reply, which avoids any discussion regarding individual characteristics of the tenant. And why do we do that? Well, we're worried about fair housing, right? So we certainly don't want to answer a question, what is the race of the tenants, right? Right? What is their religion? What is their ethnic background? Do they speak English, right? We will be concerned about these kind of questions for fair housing discrimination reasons. All right, so let's go on to the next slide, and you'll see the example of correspondence. Okay, so dear agent, we received your request for information regarding the tenant. With deference to fair housing considerations and a general concern for privacy, my response regarding the tenant is limited. I am told by the seller, so see there, you got the attribution to the seller, and am authorized to share, so you've had a discussion with the seller about this, am authorized to share with you the following information which agent broker have not and will not verify. And here it is. A professional and standard background check and credit history was conducted at the time the tenant submitted her application, including an employment history. The seller was satisfied with her application and chose her based on her qualifications. That's generic, certainly possible. To the best of my knowledge, and according to the estoppel document provided by the tenant and included in the disclosure packet, one person resides at the property with one pet, a cat named Sunshine. As per the estoppel paperwork and the lease, the tenant has resided here since such and such a date, and her lease, which includes a security deposit and a pet deposit, expires on such and such date. The tenant pays her rent on time through an automated deposit check. The tenant is locally employed. The disclosure packet includes this, and recent correspondence with the tenant regarding her lease and potential future renewal. Buyer is advised to consult with a local landlord attorney for questions regarding tenants' rights, landlord rights, and especially questions regarding the owner's desire to take possession of the property. Neither seller nor the agents are qualified to provide legal advice and cannot comment on issues such as rent control, eviction control, or AB 1482. That is the statewide rent and eviction control. So this would be a decent format for such a letter. And someone points out Roxanne. I love that, Roxanne. Her, shouldn't you say there? You know what's so funny, Roxanne? As I read the her, I thought to myself, you know what? It would probably be my newer practice of making it generic to they and her, their rather than he, she. Okay. Is it possible for you to email all of these slides? You know what? Genevieve could possibly do a thank you for an email, the next email that says, thank you for those of you who attended the last one. Here's a copy of Dan's slides. So we could probably do that. Okay. All right. Okay, cool. Any questions on this one before we move on to the next? Okay, let's move on to the next. So you see how this is in order. Here's the next question. Does the seller have to answer buyer's list of questions? Right, so the last three slides came in response to a buyer's list of questions. And so the answer is no. The seller doesn't have to answer a buyer's list of questions. So if there are statutory disclosure requirements, well, there are statutory disclosure requirements, right? And there's a few that we saw, which was like when asked about EV stations, the buyer needs to provide information. But if the buyer doesn't have that information, then the answer is we don't have that information. But typically what we get is a whole bunch of questions that are just sort of frustrating for the seller. And sometimes we get these questions after we're into contract, and sometimes we get these questions as part of the investigation contingency, or sometimes we get them after the investigation contingency, or all contingencies for that matter, have been removed. And then the question is, what obligations does the seller have? And I sort of say this. First of all, there's none. There's an obligation to disclose what's required by law and what's required by the contract. If the seller has already fulfilled that obligation, they have no further obligation. The contract does say that when the seller becomes aware of new material facts or of failure to have previously disclosed something or an inaccuracy in one of their previous disclosures, that they have an obligation to update their disclosures to correct or to disclose that new material fact. And that gives the buyer a cancellation right. But if that's not what we're talking about, it's not that the seller has discovered that they made a mistake or discovered a new material fact. If all we're talking about is the buyer has a bunch of questions, then the answer is, I don't have an obligation to answer your questions. But the issue becomes, when were those questions asked? And real estate is a lot like dating. And so where are we in this process? Are we still dating, or are we married? And if we're married, that means that we're in contract and all the contingencies are removed. And now that you're married, well, they can't leave you, or it's hard to leave you. So maybe we don't have to answer the question. And so what does our response look like? Well, if we're still in the investigation contingency, then we're still dating. And if the answer is, I'm unwilling to answer any of your questions, that may look a little suspicious. It may tend to make them want to walk away rather than proceed. But whatever the answers are, obviously need to be truthful, based on fact. And if your client doesn't have facts to back them up, your client's responses should be, I do not know, or this is all I know, and here's what my answer is based on. And we encourage you to do more investigation. So let's look at the next slide. Right? And so this is what I've just talked about. And if we go on to the next slide, then what we can look at is a possible email to the buyers, right? And so here it might be, thank you for your email. The sellers have done their best to provide all the information needed for your buyer to make an informed decision, including furnishing the buyer with an extensive disclosure packet. The sellers have fulfilled their contractual and statutory disclosure obligations. They have been counseled not to provide responses to the lengthy list of questions submitted. Should the lender require additional information as a requirement for buyer to obtain stated financing, please have the lender contact me directly with their specific requests. We will do our best to accommodate the lender as required, same as we did for the appraiser last week. So this is sort of a harsh response, but this is the response after you're already married. And the question is, why are they asking all these questions now? They had an investigation contingency. They supposedly performed their investigations. That would have been the time to ask these questions. Now it's just awkward. Now we're concerned about their motivations. And so we're going to stick to the rules and to the contract, and we're going to send this reply. Okay. Any questions on this? All right, let's switch topics. So on the next slide, you'll see we have a whole different topic. And this topic is about an FHA VA loan and its appraisal contingency rules. And so the question that was posed to me was, the contract included a waiver of the appraisal contingency, but the agent for the buyer is saying the loan still needs to be approved by the FHA VA. What if it appraises below value? Can the buyer walk? What about the deposit? So here's the scenario. We have a contract that was submitted without an appraisal contingency. It was specifically waived, but the contract did say the buyer was going to get an FHA VA loan. and the seller agreed to that and agreed to participate. Okay. And so what's the answer? Well, the answer is, unfortunately, the statute always trumps the contract, meaning the statute controls. And there's specifically a statute that says, with regards to FHA-VA loans, that the purchase is contingent on the property appraising for value. And if it doesn't appraise for the purchase price, the buyer has the right to walk away. That law was put in there to protect the buyer. The concern is that perhaps somehow they were duped into offering too much, and that the appraisal is a backstop for them just in case they were stupid and naive and entered into a contract for more than the property was worth. And so it doesn't matter what the contract says, they always have that statutory right. And so now what do you do if you're representing a seller? Well, what you can do if you're representing a seller is understand this rule, but your seller does not have to accept the offer. Or the seller could counter the offer and say that, listen, we're removing not the appraisal contingency, because you can't, because of this law, but we're removing our consent to the FHA VA loan. And if you want to get into contract with us, we require that you obtain conventional financing, right? So they could issue a counteroffer that says, quote, seller does not agree to FHA VA financing. Buyer shall obtain conventional financing. Buyer waives the appraisal contingency, right? And if buyer wants to get into contract on those terms, well, then so be it. We can get into contract on those terms. Any questions on that? Cool. Let's see what the next one is. Yes. Okay, so just to make sure everybody's still out there and to make this a little more interactive, let me ask you this question. How many of us within the last year have been in a transaction where either just before close of escrow or just after close of escrow, there's some request from the buyer to remove photos from the MLS or to remove floor plans from the MLS, right? Yes, Barbara. Barbara says, me. Yeah. So this happens all the time. Roxanne tells, yes, she's had this too. And it's very frustrating. And let me just explain one of the reasons it's frustrating. One of the reasons it's frustrating is because it doesn't matter, frankly, if we go into the MLS and remove photos. Why? Because they're already out there. They're already all over the web. So if you just, once the property gets entered into the MLS and the feeds go out to all of our MLS partners, right? They're on the internet. And if you just type in the property address, you're going to find those photos. And so if we remove them from the MLS at the end, it doesn't pull them back from the rest of the web. It's all that does is mean that someday, next year, next month, next week, when some agent is trying to run comps using our wonderful data, right? We're all part of this thing for a reason, because we have this wonderful exclusive data that we can access, right? And trying to look at the property and run comps, they're not going to see any of the photos. They're not going to see the floor plans. How is that helpful, right? You know, so it would be very nice if we could look at our own MLS and find our own data. It's not like the rest of the world is searching our MLS, right? Nobody's going to the San Francisco MLS to search, right? They're searching the quote unquote internet, right? Through the third-party feeds. So, you know, that's what's going on here. And so it's really frustrating. It doesn't even help. So a few things have happened. The contracts, both the CAR contract, San Francisco contract, and for those of you on the peninsula, the PRDS contract, they've all had language beefed up in the last year that says the parties agree that the photos and the floor plan diagrams are going to be remain on the MLS. They're going to be widely disseminated. It's difficult to pull them back, and that the realtors have no obligation to do that. So that's part of the contract, okay? Also, SFAR has created a new feature, which I think is really great one, that helps us here. And I predict that this new feature is going to be picked up by our various Bay Area partners soon, and perhaps throughout the state in the near future. And that concept here is called private photos. You can, when you enter a listing, click a box that says, I want private photos. It requires at least one public photo, right? But what it does is it creates the rest of the photos as private, meaning when this thing closes, they all sort of disappear in the IDX feeds that go out. And the partners who we deal with from the IDX have agreed that they will comply with this request voluntarily. We've done this up front. But any agent who has login access to the MLS will be able to see all of the photos, right? Including the ones that are marked as private. And so that is really handy dandy. And for now, that feature is retroactive. You can actually do that even after close of escrow. You can go back and mark them as private, okay? And that applies to any listing that closed since January 1st of this year, 2022, okay? All right, cool. What's the next one? Oh, this is just a reminder that actually going in and deleting photos just before you close out your listing is actually a violation of your MLS rules. And the next slide reinforces that, because the next slide refers to the civil code section. And there's actually a civil code section 1088C. I didn't show you A and B, but C says a multiple listing service shall retain and make accessible on its computer system, if any, all listing and other information placed in the multiple listing service by an agent or appraiser for no less than 3 years, okay? And then here's a reference to what the real estate purchase contract says, right? It says the parties consent to the MLS photos as part of the purchase agreement. That's paragraph 21. Oh, I'm sorry, this isn't actually quoting the contract. I apologize, I didn't quote the contract. All right, let's go on to the next slide. So different subject matter here. We have moved off the photos, and a question was asked to me. It says, Dan, my client knocked on someone's door and asked the person was interested in selling. Remember the old days when people used to do that? I don't know why I said my client. Oh yeah, I guess, okay. The guy said yes, so now I'm writing an offer for the buyer. How do I make sure that I get paid? Okay, so the scenario apparently is the agent has a buyer client. That buyer client has found the seller on their own. They want us to write an offer, and the first question is, how do I get paid? Okay, and so that's a really good question. If this was a listing in the MLS, then you look, of course, at the offer of compensation that's in the MLS, right? 2.5%, whatever it might be, okay? But this isn't that case. Let's presume there is no listing whatsoever, right? You're only representing the buyer. How do you get paid? Can you sign the seller up for a listing agreement? Well, you could do that. Could it be some sort of a limited listing agreement? Sure, it could be that. But if you do that, you're now a dual agent. That may not be what you want, okay? Are there other forms? Yes, there are other forms. And so two of the obvious forms are, there's a CAR form called the commission agreement, and there's another CAR form called the single party compensation agreement. And there's also another avenue, which is an agreement not that the seller pay, but that your buyer pays the commission, right? So that could be your option. And how would you do that? That would be an exclusive buyer-broker agreement. And as you may know, those buyer-broker agreements, we used to have 3 of them, are getting compressed into one. And that new buyer-broker form gets released in 2 weeks, I think it is, with the new and revised forms that we'll see in 2 weeks. So those are your options. And so let's talk about the first one, which is a single party compensation agreement, right? This form, and it's 1 page or 2, it's small. I can't remember if it's 1 or 2. I think it's 2. This form commits the seller to pay a commission on the close of escrow, irrespective of agency relationships, if the property is sold to the buyer specified. Okay, so you can write in the buyer's name, or some agents are very suspicious and they don't want to write in the buyer's name directly. They say my client, right? This form is typically used where an agent has a buyer interested in making an offer on a particular property and where the seller has no representation, right? So you can now approach the seller. You can say, I have a client. If you want to sell and if you want me to present an offer, I need to make sure that I'm going to get paid. And before I present an offer, right, I need you to sign this, and here's what this does. The agreement also specifies the agency relationships, including the possibility of exclusive buyer agency, so you'll just represent the buyer, or dual agency. If you're only representing the buyer, there's actually a CAR form that says, it's called the non-agency representation form, and it says, and there's two of them, one buyer non-agency and the other seller non-agency. You'd be providing the seller non-agency here, and you would be saying to the seller, hey, I don't represent you. Here's a form that explains that I don't represent you. It says on this form that I may even provide you with a copy of contract and disclosures that you may need to fulfill your obligations, but I'm not giving you advice on how to fill them out, and I'm not your agent. You should get your own agent, or you should get a lawyer. Okay, that's that form. That's the single party compensation agreement. And so if we go to the next page, we have a sample letter, and this would be a letter from you to the seller that says, I've attached the CAR single party compensation agreement. This form obligates you to pay a commission to me. And I say Compass here. I apologize for those of you who are not Compass agents. I put this slide deck together for my Compass agents also. To me, my brokerage at close of escrow, we cannot and will not submit an offer without first confirming the right to a commission at close of escrow. Before proceeding, I encourage you to seek representation by a real estate agent or broker or a qualified real estate attorney. And then the second part here is all about, I'm not your agent, right? As discussed, neither myself nor Compass are representing you in the sale of your home. I represent the buyer only. See the attached CAR form seller non-agency agreement, which confirms the agency relationship or non-agency relationship in this case. As set forth in paragraph 2, all actions taken by me, including providing you with blank copies of the standard disclosure forms, are taken on behalf of and for the benefit of my buyer client. Further, none of our communications are private or confidential. Please sign and return the attached form. Also attached for your information is a copy of the CAR form disclosure regarding real estate agency relationships. You could also send them at this point a blank copy of the contract if you wanted, right? That could also be helpful. Okay. Any questions on this before we go on to the next slide? All right, on the next slide. Yes, Jessica, so we have a couple of attachments there, I agree. So on the next slide, we have that other form. Well, what's the commission agreement, right? So the CAR form CA, commission agreement, broadly commits the principal, typically the seller, to pay the broker a commission regardless of agency relationships if the property is sold prior to the date identified. And so this form is typically used where the agent has a relationship with the seller, as opposed to the last example where your relationship is with the buyer. So you have a relationship with the seller. You've been talking to the seller about the possibility of selling. The seller hasn't agreed to sign an actual listing agreement, but the seller has said something like, bring me an offer and I'll pay the commission then. And so you can say to the client, okay, I have somebody who's interested in making an offer on the property. Perhaps it's your own client, perhaps it's someone in your office, perhaps it's a third party, right? A broker from another agent from another brokerage. But you want to make sure you're going to get paid, right? And so you say to the seller, okay, if somebody's interested, but before I'm going to tell them to pull the trigger and send an offer, I need to make sure I'm going to get paid. And this simply says that if you close on that deal or a deal before this date, then I get paid. So that's the commission agreement. And for those of you who are like, why can't we just write an offer and put our commission in the offer in additional terms? Well, the reason you can't do that is it's an NAR Code of Ethics violation. So the idea there is before you write the offer, let's negotiate what the commissions will be. Otherwise, you have a real issue with your ethics and your fiduciary duty if you add it to the mix inside the offer. Okay? All right. Cool. Let's do one more, and then we will call it for the day. Let's see what our questions are. Yep. Okay, we're good. All right, last one for today. This one is all about contractor, foreman, stager, realtor. Who am I? And the question was, I've been thinking that there's so much work being done to fix up houses for sale that I might as well get my contractor's license so that I can be a one-stop shop, realtor and licensed contractor. Isn't that a good idea? Well, if you are an independent broker and you are paying for your own E&O insurance and you think you have coverage for this kind of thing, and this is going to be your business model, that's up to you. But if you are an agent or a broker associate working under Coldwell Banker, Compass, whomever, this is a terrible idea. It's most likely that when you go down this route and you get sued, you may very well get sued not just for breaching your realtor duties and breach of fiduciary duties, but also get sued based on these other things for which you do not have errors and omissions insurance, for which you will be out on your own. So I say in my answer here, oh dear, any such arrangement significantly adds to your risk and liability and exposes your company to additional claims. Before proceeding, your broker will require you to sign some hold harmless and indemnity agreement and show all kinds of proof of separate insurance and require that you have probably a separate email address for that business and that you bifurcate, separate all of your emails one to the other. And then frankly, if your broker is smart, they'll just tell you you can't do this. And if you continue to do this, you can't work for us anymore, because it's just going to create all kinds of entanglements. And this is true, frankly, with any and all financial entanglements other than the actual commission. So some companies like Compass has this concierge idea where the company will be providing money, right? Many tens of thousands of dollars to assist the buyer in the seller in fixing up the property. This is a great idea because it relieves you of that temptation to lend money directly to your client. Lending money directly to your client is a terrible idea because of the financial entanglements. Later, they're going to say that you pushed them to accept an offer that wasn't a great offer. Why? Not just because you wanted your commission, because you want to get paid back your $50,000, right? So it really becomes a perceived conflict of interest. Very difficult with your fiduciary duty, right? So now the question that you ask is, okay, but I want to make sure that I'm adding value, right? I don't want to be a contractor. I don't want to be the foreman, but I want to really help them through this whole process. And isn't that what I'm supposed to do? Oversee all of the improvements to the house? The answer is yes and no. And let's go to the next slide. We'll show you some best practices, okay? So your best practices are, listen, I'm not your foreman, I'm not your contractor, I don't have a license for that. In fact, the Department of Real Estate has been really very specific on this, and they're disciplining people who act as a project foreman, as a contractor, when they're just the realtor. And so what you can say is, listen, I'm a project liaison. I'll assist you, seller, in making design choices and coordinating a comprehensive design aesthetic for the purpose of appealing to prospective buyers and achieving the maximum sales price. But I will not and I cannot act as a project manager. I can't be your general contractor. I can't be your foreman. I can't oversee and coordinate actual construction and remodel projects. You, seller, need to enter into direct agreements and contracts with the construction professionals and the vendors. But I am more than happy to meet with all of them, right? And with you to help you choose finishes, for instance, because why? I'm the one who knows what the buyers want. I'm the one who can help you say whether or not spending $50,000 on new flooring is something that will give you the ROI in the end. And I can pull comps and show you different properties that have different features that help us make that determination. I'm the one who can help you decide whether or not spending $100,000 on the kitchen is worthwhile and what gadgets to include in that kitchen, right? And however, I'm not your foreman and I'm not your general contractor. And if you need one of those, here are some people who act as such. And so I give you some examples here because these companies do exactly that. They are a go-between between the realtor and the seller, and they help do the actual work and keep you out of it so that you're not overstepping boundaries, okay? And by the way, for any of you who have a pickup truck, sell it. Having a pickup truck and being a realtor are a terrible idea, okay? And so here's why it's a terrible idea. Because ultimately they're gonna say, hey, can you go to the tile company and pick up that tile? And you're gonna go to the tile company and you're gonna pick up that tile. And when you get there, it's gonna turn out it wasn't paid for and now you gotta pay for it. And now who knows whether or not you get paid back. Or how about this one? This one happens all the time. You go pick up the tile or you go pick up the paint, right? Then it gets installed and the client sees it and the seller says that looks like shit and that's the wrong color and that's the wrong tile and I'm not going to pay that $15,000 and I'm not paying you back and that was your fault. You need to do something about it, right? So sell your pickup truck. No good deed goes unpunished. All right. And finally, I'm looking at the chat. What about producing realtor side hustle notary? Realtor plus, realtor plus a side hustle notary. You know, I don't know, Roxanne. The only deal with that concerns me is if you're having I would be worried if you're the notary in your own transaction. I would avoid that. I don't have a problem with you being a notary as a side hustle. I would just not be a notary in your own transactions, okay? In fact, I love side hustles. Good for you. If I could figure out how to get paid for this, turn this into a side hustle, boom, I'd love it. All right. Okay, so how did we do today? Do we have any other questions? Does anybody want to open the microphone and ask any questions? Otherwise, I'm going to save the rest of these topics for the next time. Hearing no particular questions, I'm going to determine that it was a success, that we learned something today, and that hopefully this was helpful. Oh, wait, Trent has a question about tanks. Trent, Golden Gate Tank has the monopoly for underground tank inspection. However, they destroyed the past records, so have to do with tank inspections again and again for the same house every time, blah, 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 blah. So Trent, that should be your side hustle. So you and the woman who was doing the side hustle as the notary, I think that was Roxanne. I think the two of you should get together and open up the new Golden Gate Tank Company. You could call it the Bay Bridge Tank Company and go into competition with them. All right. All right, thank you guys. Totally appreciate all of you. Glad to be here. Hopefully you found this helpful.
Thank you, Dan.
Thank you, Genevieve. I'll see you later.
Okay.
Bye, everybody.